Okay, folks. So the problem with my sound is now fixed. Sorry it took so long. Happy you hung in there, though. I appreciate that. So, of course, you know by now that the Supreme Court has granted a very great measure, of immunity to the president, to the occupancy of the presidency, uh, for acts that he does, as president. I'm going to get into the specifics here. Okay, then I'm going to get into meanings. Sorry about that. Didn't mean to show that. Let's get to the first of the pieces that will allow us to talk more specifically about this particular problem. First, we'll look at a piece from Common Dreams by Jake Johnson. It was published today. Somebody has a sign: plotting to overturn an election is not an official act, it's a crime. I'm afraid I agree. Right-wing Supreme Court rules Trump has absolute immunity for official acts. In every use of official power, the president is now a king above the law, unquote, warned Justice Sonia Sotomayor. Quote, with fear for our democracy, I dissent. Yes, the decision was a 6-3 decision by the Supreme Court. This piece was written by Jake Johnson on July 1st, 2024, from Common Dreams, of course. The U.S. Supreme Court ruled along ideological lines on Monday that former President Donald Trump is entitled to, quote, absolute immunity, unquote, for, quote, official acts taken while he was in office, a decision that liberal Justice Sonia Sotomayor warned makes any occupant of the Oval Office, quote, a king above the law. So I want to make one point right now. The current president of the United States, Joseph R. Biden, is also a king, above the law. Now, Donald Trump is no longer a king above the law for actions he takes now. But the question, of course, is, was he a king above the law when he took certain actions while he was president? And that's the interesting thing here. Writing the majority in the 6-3 decision, Chief Justice John Roberts declared that Trump, quote, may not be prosecuted for exercising his core presidential constitutional powers, and he is entitled at a minimum to a presumptive immunity from prosecution for all his official acts, unquote. Now, what does this mean? We'll be going through it to catch the meaning of this, but Sotomayor countered in her dissent that the majority distorted the concept of core constitutional powers, quote, beyond any recognizable bounds, unquote, effectively granting Trump the sweeping immunity he demanded as he faces charges for attempting to subvert the 2020 presidential election in a failed last-ditch bid to remain in power. Quote, when he uses his official powers in any way under the majority's reasoning, he now will be insulated from criminal prosecution. What does she mean, by insulated? She means that he is entitled at a minimum to a presumptive immunity from prosecution for all his official acts. But what does that mean exactly? There's a presumption, that he's immune, but he's not necessarily immune. Again, what does that mean? We'll be exploring it. Sotomayor wrote orders the Navy's SEAL Team 6 to assassinate a political rival. Um, uh, um, Immune. Hey, Joe Biden, what about that? Organizes a military coup to hold on to power. Immune. Hey, Joe Biden, what about that? Immune, immune, immune. Quote, in every use of official power, the president is now a king above the law, the justice added. Quote, with fear for our democracy, I dissent, unquote. The New York Times noted that the court has remanded the case to the federal district court judge overseeing the matter, Tanya Chutkin, to determine the nature of the acts for which former President Trump has been charged, which are unofficial ones he undertook in his personal capacity, and which are official ones he undertook as President of the United States. Seems to me the speech he made to the Proud Boys and other people who were thinking of marching on the Capitol, seems to me those were unofficial ones. Doesn't it seem to you that was the case? The High Court's ruling, which came after months of delay, all but forecloses the possibility of Trump facing trial for election subversion charges before the November presidential contest. The Progressive Advocacy Move On group, Move On, said the conservative supermajority's decision to punt the case back to the lower court makes the justices, quote, complicit in Trump's plan to delay any legal accountability until after the election, unquote. Well, he does have the legal accountability from the New York State conviction, of course. Two of the court's right-wing justices, Clarence Thomas and Samuel Alito, faced calls to recuse from the case, but they rejected them. Quote, Donald Trump incited the deadly January 6th insurrection, and the MAGA Supreme Court continues to do everything in their power to stop him from facing accountability for attempting to overthrow our government, unquote, said Rania Epstein, executive director of Move On Political Action. Quote, nobody is above the law, especially not Trump. MAGA extremists in Congress and the courts have made it clear there will be no checks or balances on Trump, and the only hope for American democracy is the people coming together to defeat him in November. Hey, Joe Biden, how about declaring martial law right now? How about that? That would be an official act. That would mean you could declare martial law and you could postpone the election. Until when would you be able to postpone the election? Until the legislature passed a law expanding the Supreme Court to 15 people. How about that? Lisa Gilbert, executive vice president at Public Citizen, added in a statement that, quote, Trump versus the United States is a fitting name for this case. Quote, there is no better way to characterize Trump's attempt to upend the Constitution and rule of law as we know it. Unquote. Quote, today's ruling is a blow to U.S. democracy, but it's not a final blow by any means. Trump can and should still be held accountable for his role in the violence on January 6th in an attempt to overturn the 2020 election and stop a peaceful transfer of power. In an amicus brief submitted in April, Public Citizen noted that the president has no specific constitutionally assigned role in the conduct of presidential elections, unquote, making, quote, any assertion that a president's authority empowers him to conspire to overturn the result of a valid election and retain power beyond his term in office, absurd, unquote. Unquote again, accepting a view of the outer limits of presidential authority that would sweep in a conspiracy to overturn an election and remain in office unlawfully would have exceptionally broad implications and threaten severe damage to our constitutional democracy, the group warned. And that is that piece from Jake Johnson, dipping our toes into the issue of what this decision by the Supreme Court actually means. Unfortunately, of course, we won't have the time tonight to read the decision, but we will have the time to explore some implications. So, here is a video from the Midas Touch, and I'm just going to play a little clip for you and comment on it as it goes on.
Supreme Court has just ruled in favor of Donald Trump, saying that Donald Trump has absolute president immunity for crimes committed that can be considered official acts. The right-wing supermajority in that 6-3 decision not only gave Donald Trump what he wanted, but in fact went even further than what Donald Trump was asking for, saying that Trump has absolute immunity for official acts, and then that a president who can claim that their conduct constitutes official acts cannot even have those acts used as evidence in other proceedings at all. Here's what Mark Joseph Stern says. He goes, "Today's decision is about as big as a win for Donald Trump as he could have possibly wanted for or expected. The conservative supermajority creates a sweeping new kind of presidential immunity that will insulate many of his allegedly criminal acts from indictment or prosecution." For Donald Trump, this is exactly what he was asking for when he says he can order SEAL Team 6 or the military to kill his political opponents, and that would be considered an official act that now would be subject to absolute immunity.
Well, I'm not sure that's a correct interpretation, because sometimes the specifics work out so that what things seem to mean they don't actually mean. But that is a reasonable interpretation of the decision. Okay, at this point, the only qualification I put in is that the absolute immunity refers to the president's core constitutional functions. Okay, a conspiracy to kill a political opponent is, I offer, not one of the core constitutional functions of the president. The president may claim that doing that, okay, is an official act, and that may give him a presumption, and there may be a presumption, okay, that he is immune from prosecution, because as the Supreme Court says there is presumptive immunity. However, what presumptive immunity means is that the burden is on the prosecution to prove, okay, in that case, that the official acts in question were actually official acts. The implication of the decision is that it's not enough for the president to claim they are official acts, that whether they are official acts or not official acts can be adjudicated. At least I think that's one of the implications of the decision. Of course, again, the burden of proof would be on the prosecution to prove that. Okay, meaning when a case went to court, there would be an objection from the lawyers for the president that this was an official act and therefore beyond any accountability. And the prosecutor would have to make the case, okay, to the judge that overcomes the presumption, okay, of innocence in this case, okay, or the presumption, okay, of okay, that these acts are really, okay, an official act. But let us go further and see what else our friends at Midas Touch have to say.
You know the severity of this ruling from the dissent and the three appointees from Democratic administration, Justice Sotomayor, Justice Kagan, and Justice Ketanji Brown Jackson, wrote about as grim and as dark and as frankly terrifying of a dissent as I've ever read in the history of the Supreme Court. Justice Kagan signs off on her dissent with saying, "With the fear for our democracy, I dissent." And this is what Justice Sotomayor states. She goes, "Looking beyond the fate of this particular prosecution, the long-term consequences of today's decision are stark. The court effectively creates a law-free zone around the president, upsetting the status quo that has existed since the founding. This new official acts immunity now lies about like a loaded weapon for any president that wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation. The president of the United States is the most powerful person in the country and possibly the world. When he uses his official powers in any way under the majority's reasoning, he now will be insulated from criminal prosecution. Ordering the Navy SEAL Team 6 to assassinate a political rival, immune. Organizing a military coup to hold on to power, immune. Taking a bribe in exchange for a pardon, immune, immune, immune.
So, okay, we have to ask the question, what if the president ordered his people from the Department of Justice or to the FBI to go over to the Supreme Court and arrest all the justices of the Supreme Court and throw them in jail indefinitely? And what if he claimed that that was an official act? How would the Supreme Court feel about it then? Would they still think he's immune, 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 immune? Just asking a question.
The president violate the law, let him exploit the trappings of his office for personal gain, let him use his official power for evil ends, because if he knew that he may one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That is the majority's message today. Even if these nightmare scenarios never play out, and I pray they never do, the damage has been done. The relationship between the president and the people he served has shifted irrevocably. In every use of official power, the president is now the king above the law.
Yes, absolutely. That was a nice statement, okay, by Ben Meiselas, who is the lawyer that you just heard talking. Now we'll go a little further.
That the Supreme Court has just anointed the president as the king. Then you had Justice Ketanji Brown Jackson in her dissent saying the same thing, that the majority has just said that when Donald Trump's in office, or any president at that matter, has king-like power, is not responsible to we the people, and all they have to do if you're in office is claim that your conduct is an official act, which the Supreme Court gives broad latitude, broad presumptions of what constitutes an official act, and you get absolute, total immunity from any conduct at all. Popak, this decision from the standpoint of our democracy, I don't want to sugarcoat it. I don't want to mince words, because this could not be worse for our democracy, and everything that Donald Trump wanted and more, they've essentially given him. The right-wing Supreme Court here. What's your take on this?
We can't blow sunshine here. It severs the relationship between the presidency and making him be respectful and beholden to the people that put him into that office. It changes the balance of power while claiming that it's merely reinforcing a separation of powers, which was repeated time and time again by Chief Justice Roberts, joined by his 5 other right-wing MAGA Supreme Court justices in the ruling. They're just saying it's just about separation of powers. But it used to be a co-equal branches of government, checks and balances on each other. That has now been destroyed by the way they've categorized the three types of conduct that they're now going to require all trial courts, including Judge Chutkan, who's been patiently waiting along with our democracy for the results of this decision, rendered on and dropped on the last day possible, leaving absolutely no time to put this trial on. There's now three categories of conduct that have to be evaluated by a judge in looking at an indictment. And then I'm going to tell you quickly which of the ones already in the indictment are out completely from the four different categories of behavior that the Donald Trump was indicted for. Firstly, if we're talking about things, there's a subset of conduct or powers, if you will, of the presidency, which we usually refer to as core presidential powers. They are literally expressed in the U.S. Constitution: the power to appoint, the power to remove, the power to conduct foreign policy. The things that are expressed in the Constitution, those core presidential powers have now been, if the indictment relates to those and the conduct there, that is absolutely immune. Now, many.
Okay, the power to conduct foreign policy. What happens if the president turns out to be complicit, in the genocide that is now being conducted by Israel, in Gaza? What if an international criminal court finds the president, to be complicit? Well, here the Supreme Court, is saying that since the president has absolute immunity or presumption of such anyway, with respect to, I'm sorry, I withdraw the presumption point. The conduct of foreign policy is one of the core functions of the president. So the Supreme Court out and out said, with respect to core functions, the immunity is absolute. Absolute. So the president can commit genocide. The president can be complicit, in genocide. And he would have absolute immunity from the International Criminal Court. As far as committing genocide, is concerned, he wouldn't have any accountability for that either. Seems like this decision of the Supreme Court is in conflict with the United States signing of the Genocide Convention of 1948. But let us go further.
Many of the things in the indictment do not relate to the core presidential powers as I just laid them out. But then they then said there's a second bucket. The second bucket is official conduct. Doesn't go as far as being from the literal text of the Constitution, not core presidential powers, but official conduct. And that's going to be given a presumption of immunity that is very difficult to overcome.
It has been given a presumption, of immunity. It's not something in the future. It was given it by the decision of the Supreme Court.
And a trial judge is going to have to evaluate whether the conduct that's being indicted, if prosecuted, would rise to the level of improper interference with the executive branch. And if it does, the phrase is danger of intrusion on the authority and function of the executive branch. And if it does, the presumption cannot be overcome and immunity is given for official conduct. Now we're down to unofficial conduct, not private conduct, but unofficial conduct. And if it's unofficial conduct, right, then there is no immunity and there's no presumption of immunity. And therefore, you got to figure out which of the things in the indictment, for instance, in the Jan 6th election interference case in the Washington, D.C. and in Georgia, because that would apply there too, which of that falls into this third narrow bucket of unofficial conduct. And that has now been remanded back to Judge Chutkan for the case that's at bar right now to determine which of the elements of the indictment could fall into this narrow shot glass of a category of unofficial, not official, not core presidential power. And only that can be indicted. And to help her do her job, even though they said in the opinion that it's not for them as an appellate court to prepare a record, they told her straight out what her instructions are. As it relates to the interference, the criminal conduct of Jeff Clark and Donald Trump at the Department of Justice to try to influence the outcome of the election through improperly weaponizing the Department of Justice, that is immune. Take Jeff Clark, take everything about the Department of Justice off the table. The interactions between Donald Trump and his minions with the vice president, meaning the pressure campaign on Mike Pence, at the heart of—
Okay, with respect to Jeff Clark, okay, at the Department of Justice, that was a rendering of the president's appointment power. That's why it has absolute immunity, because it's one of the core functions, okay, that Michael Popak, okay, has mentioned.
Of the indictment is off the table. It's been declared immune. Now you're left with Chutkan having, when she gets the case back in the next couple of days, having to determine if the interactions with the election officials and elected officials would constitute unofficial or official conduct. She's going to have to do that at a hearing before she can even let this indictment go forward. And I'll leave it on this, Ben, for my part here. If you thought this was as our producer said, was we were getting ready for this, a wrecking ball to both the Constitution, the separation of powers, and a win for Donald Trump, there's more. Clarence Thomas not only did not recuse himself, he wrote a concurrence written directly and addressing directly Judge Cannon in the Mar-a-Lago case, because he says in the first page of his concurrence, I don't think the special counsel is legitimate. I think he was illegitimately appointed, and there was an illegitimately appointed special counsel, a private citizen without constitutional authority or delegation, who's prosecuting the president. That is exactly the issue that is before Judge Cannon right now, and now has just gotten renewed support from a Supreme Court justice in the majority, basically saying the special counsel was illegally prosecuting this case against Donald Trump.
And Popak, what the majority declares as well, and this is what just—
Okay, that's it for that. I wanted to give you a feeling for the three categories of functions or acts, okay, of the presidency, okay, and this idea that the unofficial acts are a narrow shot glass of things. And poor Tanya Chutkan, okay, the judge at the district court level, is going to have to determine, okay, if there are any unofficial acts that are part of the indictments, okay, thus far. Of course, this is all after the fact. None of the lawyers and prosecutors knew that it was going to be necessary to make a distinction between official acts and unofficial acts and core constitutional functions, okay, and official acts. That's completely new law, which has just been written by the Supreme Court. The Supreme Court is legislating here with its interpretation. Nowhere in the law does this kind of thing appear. So there it is. So let's go further. Oh, by the way, I guess I neglected to share this on Facebook, so let me do it now. Where am I here? Okay. I want to make sure I shared this. There we go. There we go. Maybe it'll bring some more people in from Facebook. Hopefully. Let me, hi, Evelina. Hi, Jeff. Hi, Dee. And there are a number of other people here too, but they're not in the comments, so I cannot tell who they are. Well, let's get to the next piece. Okay, this one's by Tom Hartman. The Supreme Court just turned Trump into the first American king. The 6 Republicans on this court have essentially declared that they and Trump are so far above the law that the entire concept this nation was founded on, that, quote, no person is above the law, unquote, is null and void. This was written today, July 1st, 2024, by Tom. They did it. The U.S. Supreme Court handed a massive victory to former President Donald Trump in this so-called immunity, quote-unquote, case. And it will probably take a year or more before there's even a chance he'll be held to trial for trying to overthrow the 2020 election and thus the government of the United States. As feared, 6 Republicans on the court essentially threw Trump's sedition case back to the lower court with caveats, where there will be numerous decisions to make, which are all further appealable, resetting the case so Trump can drag things out for another year or more about whether the crimes he's committed are, quote, official or, quote, private/personal acts. I don't think private personal acts were cited in these decisions. It's the distinction between the core constitutional acts, the official acts, and the unofficial acts. But that's not the worst of it. They turned Trump or any future fascist president to a first American king or Führer. Again, I have to emphasize, and I'm going to emphasize this again and again, and again. Joseph R. Biden is the president of the United States. He will be the president of the United States at least until January 20th of 2025. It seems to me he can do a huge number of official acts which are very damaging to those who think that the president is above the law, that he can clearly demonstrate to them what the president being above the law actually means. Now, I'm not suggesting that he do that, but after all, what's good for the goose is good for the gander. Unless Congress acts quickly to overturn this obscene 6-3 decision, which won't happen so long as Republicans control the House, democracy in America has been wounded, perhaps fatally, and the president has been made into a dictator should he or she choose to behave that way. And of course, no matter what little fig leaves exist in this decision, if he's elected this fall, he'll appoint a corrupt attorney general who'll make Trump's attempts to overturn the 2020 election all go away immediately. Chief Justice Roberts went so far as to say in this corrupt decision that Trump's speech exhorting people to attack the Capitol and try to hang Vice President Mike Pence and his failure to bring in the National Guard or ask his rabid followers to back off are part of his, quote, official responsibilities, unquote. That's ridiculous. That's mindless. Speaking to Trump's calling his rioters to overthrow the election, Chief Justice Roberts bizarrely writes that, quote, most of the president's public communications are likely to fall comfortably within the outer perimeter of his official responsibilities, unquote. Justice Sotomayor is having none of it. Her dissent summarizes the situation elegantly. Today's decision to grant former presidents criminal immunity reshapes the institution of the presidency. It makes a mockery of the principle foundational to our Constitution and system of government that no man is above the law. Relying on little more than its own misguided wisdom about the need for bold and unhesitating action by the president, the court gives former President Trump all the immunity he asked for and more. Because our Constitution does not shield a former president from answering for criminal and treasonous acts, I dissent. She adds, the court now confronts a question it has never had to answer in the nation's history: whether former president enjoys immunity from federal criminal prosecution. The majority thinks he should, and so it invents an atextual, ahistorical, and unjustifiable immunity that puts the president above the law. The majority makes three moves that, in effect, completely insulate presidents from criminal liability. 6 Republicans on this court have essentially declared that they and Trump are so far above the law that the entire concept of this nation was founded on, that, quote, no person is above the law, unquote, is null and void. All a future president must do if they want to commit a crime, as Justice Ketanji Brown Jackson's dissent demonstrates, is to claim that no matter what they did, it's merely an, quote, official act, unquote, including specifically directing the Attorney General to commit crimes himself. This is the sort of decision you get from a court in Putin's Russia. As I don't know if you get this sort of decision from a court in Putin's Russia. I don't know if Putin's Russia is that bad. As Justice Sotomayor's dissent lays out clearly, the main takeaway of today's decision is that all the president's official acts, defined without regard to motive or intent, are entitled to immunity that is, quote, at least presumptive, unquote, and quite possibly absolute, unquote. Whenever the president wields the enormous power of his office, the majority says the criminal law, at least presumptively, cannot touch him. This official act's immunity has, quote, no firm grounding in constitutional text, history, or precedent, unquote. Indeed, those, quote, standard grounds for constitutional decision-making all point in the opposite direction. No matter how you look at it, the majority's official acts by immunity is utterly indefensible. She adds correctly, the Constitution's text contains no provisions for immunity from criminal prosecution for former presidents. I don't even know if it contains any provision for people who are the president. I know the Justice Department has created some doctrine that it's not going to prosecute but sitting presidents, but that's not in the Constitution. That's not in the Constitution. Certainly, nothing about former presidents is in the Constitution. Justice Jackson makes it even more clear, in the bluntest of language, that this court, acting like kings and queens themselves, have turned the former president into their peer, a king, with little or no accountability to the rule of law. She wrote in her dissent, to fully appreciate the profound change the majority has wrought, one must first acknowledge what it means to have immunity from criminal prosecution. Put simply, immunity is exemption from the duties and liabilities imposed by law. In its purest form, the concept of immunity boils down to a maxim, quote, the king can do no wrong, unquote, a notion that was firmly, quote, rejected at the birth of our republic. It was rejected long before that. It was rejected in England by the Cromwellian Revolution. Firmly rejected. To say that someone is immune from criminal prosecution is to say that, like a king, he is, quote, is not under the coercive power of law, unquote, which, quote, will not suppose him capable of committing a folly, much less a crime, unquote. Thus, being immune is not like having a defense under the law. Rather, it means the law does not apply to the immunized person in the first place. Conferring immunity, therefore, quote, creates a privileged class free from liability for wrongs inflicted or injuries threatened, unquote. Unless Congress acts quickly to overturn this obscene 6-3 decision, which won't happen so long as American Republicans control the House, democracy in America has been wounded, perhaps fatally, and the president has been made into a dictator should he or she choose to behave that way. When we have President Biden, who respects the fundamental law, history, and traditions of America, we'll be safer now. On the other hand, if Trump or any other fascist Republican becomes president, he can pretty much do anything he wants. The imperial presidency is now officially here, not just rhetorically, but in actuality. The 6 Republicans on the Supreme Court today did massive, perhaps irreparable violence to our republic. We're in huge trouble. This court is out of control. The Senate needs to act. Senator Dick Durbin. If Trump is elected, the 6 Republicans just gave him near Putin-like powers to end our democratic Republican form of government, as Justice Gorsuch said, quote, for the ages, unquote. Okay, what can we do about this? Now we get to the question of what can we do about this? Well, we are coming up, okay, on an election. I was only half kidding when I earlier suggested that Joe Biden could exercise the new powers that have been conferred on him by the Supreme Court. And he can do this in the service of saving democracy. Specifically, he can perform all kinds of official acts which cripple the Republican Party's chances to win both the Congress and the executive branch. He can put all, I'm not going to specify what he can do, but it's clear from this decision that there are all kinds of official acts the president can perform, which would be either within his core functions or within his official acts, where he has a presumption, okay, of immunity for prosecution. And he can use this extreme power to cripple the Republican efforts in the coming election. If he can do that, and if he can deliver a Republican defeat in the House of Representatives, or help to deliver a Republican defeat in the House of Representatives, and a Republican defeat, okay, in the Senate, he doesn't have to even engineer a Republican defeat in the presidency, because we can note simply that Joe Biden is the president until January 20th, and that the new Congress takes power on January 3rd. So there are 2 weeks in between those two dates. And what the non-Republicans who have been elected to office, notice I say non-Republicans, because certainly if Green Party people, okay, are elected to Congress, okay, and if fairly lefty Democrats, okay, are elected to Congress, and this occurs in both the House and the Senate, okay, all across the country, then the legislature would be able to pass laws or pass a single law that nullifies this decision of the Supreme Court and makes it clear that the president doesn't have this kind of immunity as a matter of law. Tom Hartman, whose article I'm reading here, is, as I am, familiar with Article 3, Section 2 of the Constitution, which allows Congress to specify in the laws it passes whether there will be jurisdiction for the Supreme Court to review a particular act of Congress. Congress, therefore, can pass a law which nullifies what the Supreme Court just did, and it can use the wording of the exceptions clause in the Constitution to prevent the Supreme Court from taking up the case, or any appeals court from taking up the case. So Congress has the power to nullify this decision of the Supreme Court. The president can sign the act between January 3rd and January 20th, and it would come into law, and this decision of the Supreme Court would be nullified. The new Congress would also see to it that this decision stays nullified. Furthermore, the Congress could pass a law which nullifies the Department of Justice's ruling that a sitting president cannot be prosecuted. That law would also pass before President Trump, even if he wins, takes power. If he does take power, then, okay, at that point, he would still be subject to prosecutions. He would not have immunity. He would not have Department of Justice immunity. He would not have Supreme Court immunity. So the cases could go forward, okay, against him. And we would no longer have our first American king, okay, or Führer. That's what we could do to stop this. By the way, in the 2 weeks, well, it's a little more than 2 weeks. It's difference between January 3rd and January 20th, so it's 17 days. In those 17 days, Congress could rush through a bill expanding the Supreme Court to 15 people. Joe Biden could have his nominees all lined up to put on the Supreme Court. And they could be confirmed by the Senate. And they could be sitting when Donald Trump actually takes office. And the 6-3 majority in the Supreme Court would have been turned to a 9-6 majority against the 6 Republicans who've been controlling the Supreme Court. And their sway over the Supreme Court would then be gone. That's if Donald Trump's elected. But with the powers Joe Biden could wield, just given to him by the Supreme Court, I'm sure he would be able to put all kinds of obstacles in the way of Donald Trump actually getting to the White House. Okay. I think that Biden is no longer physically and mentally fit to serve as the president of the United States. But he may be perfectly able to stay in power until July 20th, but I think he should indicate that he will give up the presidency, okay, at that point. And I think the Democrats should go ahead and nominate someone else and give them a chance to run against Donald Trump. Certainly, the third party candidates should have their fair shot, okay, at the presidency, including Bobby Kennedy and Jill Stein and Cornel West and Claudia de la Cruz. All of that should happen. But I've outlined how this decision of the Supreme Court could be nullified. By the way, before I leave, which I will do very shortly, there is another decision of the Supreme Court that has to be nullified right away. Right away, it has to be nullified. Specifically, there's another decision that was just made by the Supreme Court. And that decision, okay, let me bring it up here. Okay, I'm going to bring this up. I don't know if you can see this, if I've appropriately shared it. There we go. I think I'm now sharing it. Okay. This is a very short article. It's by Ketanji Brown Jackson. I'm sorry, it's about her. Let me go through the piece. Where do I have it here? Oh, there it is. Okay, so there is Ketanji Brown Jackson. Justice Jackson warns new ruling could devastate federal regulators. Okay, so what happened? Okay, the Supreme Court just the other day ruled 6-3 in Corner Post Incorporated versus Board of Governors of the Federal Reserve System that the Administrative Procedures Act, the APA statute of limitations period, does not begin until the plaintiff is adversely affected by a regulation. The ruling reverses a lower court's dismissal of a lawsuit filed by Corner Post, a North Dakota truck stop, to challenge the U.S. Federal Reserve rule capping debit card swipe fees because the 6-year statute of limitations on such challenges had passed. Monday's ruling makes it much easier to sue government agencies. As Sidney Bryant and Devin Ombras at the Center for American Progress explained, okay, the decision is intended to allow a swarm of legal challenges to rules that have protected the American people from bad actors and corporate malfeasance for decades. Okay, what's at issue in this case was last week in a 6-3 decision, the Supreme Court overturned the so-called Chevron doctrine the legal principle under which courts defer to federal agencies' interpretations of ambiguous laws passed by Congress. While numerous business advocates welcome Monday's ruling, a broad range of consumer labor and other groups echoed the alarm in Jackson's dissent. Quote, Americans expect that safeguards will protect us and our families from unsafe food, products, polluted air and water, and dangerous and unfair working conditions. This decision provides special interests opposed to the safeguards people rely upon, with more opportunities to challenge and seek to overturn these important protections, said Rachel Weintraub, executive director of the Coalition for Sensible Safeguards. Chevron was overturned. That means there's going to be a flood of litigation against the regulatory agencies, stopping them from regulating corporations, increasing the power of large corporations and making individuals in this country increasingly subject to rule by the corporates, as if they did not already have enough power by virtue of all the money they spend in politics to select the representatives they want. Anyway, that is another decision that has to be nullified by the Congress. It can be nullified again in the 2-week period between January 3rd and January 20th. And Joe Biden can sign the new laws reversing this decision of the Supreme Court. While we're at it, a third decision of the Supreme Court could be reversed also in this period. That other decision is the Hobbs decision. That, of course, overturned the Roe v. Wade law, or the Roe v. Wade judicial decision. So Congress can pass Roe v. Wade into law, or a version of it, into law, and they can use the exceptions clause to prevent the Supreme Court from reviewing that. And that is, I think, what ought to be done. So it's after 9. I have to go over and help out, with Dee. I hope you like this stream. There are concrete things that people can do, but this begins with a resounding defeat for the Republican Party, in the coming election. If you're after these Supreme Court decisions that are so harmful to us and so important, then the Republican Party must be defeated in Congress. And of course, it's better if they're defeated for the presidency as well, so they don't have a leg in any of the branches, because, of course, as I described, Congress could, assisted by Joe Biden, pack the court with another 6 justices in the period between January 3rd and January 20th, 2025. Anyway, you heard this proposal here first. I hope you'll begin to repeat it and that it will begin to circulate. I hope these ideas will begin to circulate. L. Stephen Day says, hi. Steve Day says, would like to stay. My connection at home is a mess now for more than 2 weeks. It started with Meta disallowing me to share Pavlina Chernyeva's JG FAQ. That's awfully strange. What the hell is wrong with Pavlina Chernyeva's JG FAQ? That's ridiculous. Steve Orbison, I am here. Biden has dementia. Joe does not. I don't yet. My mother died of it. Who? I don't know who you mean by who. You mean Ketanji Brown Jackson? She's the latest Supreme Court justice, if that is who you mean. Anyway, I think that ends this show. I'm going to go over and help D. I'll be back tomorrow with an international relations show, unless I've generated too much controversy with this show and all the suggestions for Biden to run wild in his last period, in office. He's already been running wild in international relations. I think he should stop that, turn his attention to domestic affairs, and run wild against the Republicans there. After all, he's immune from prosecution, says the Supreme Court. I think I want to make the Supreme Court regret that particular decision. I want them to personally regret that particular decision. On that note, I'm going to end the stream.